Okay. Okay, Brandon.
MedBix Webcast is a new kind of healthcare media channel to break the silo mentality and foster interdisciplinary thinking. Our mission is to fill that gap and to create a curiosity through different lenses, tapping the passion that guided the historical figures in medicine and bringing present-day groundbreaking research to the front lines. We interview physicians and leaders in the industry about present-day healthcare challenges on our live podcast.
Welcome to the MedBix webcast. This is Raman Anam. I'm the host. I'm not Albert Einstein, but that we have a guest who belongs to the same tribe as Albert Einstein is going to be with us. So we have a special program today. We have a lot of people from India, United States, a lot of doctors that are a lot of physicians watch my program. So they want to do either they want to be entrepreneurs, or they want to fund somebody, one of their relatives. They want to fund it. There's always this what they need to know. This is the we need there's a one of the our guest is going to explain. Our guest is his name is Royse, is a longtime friend. Royse is a attorney in Silicon Valley. He is from Palo Alto, California, and then he is a he held prestigious positions in the California Bar Association, and he has a and also he's also specialized in some agriculture technology. I'm from a southern state in India, from a small village, agriculture based state. I'm from Andhra Pradesh, it's called. And then where I went to Atlanta, Georgia, where the peanut farms are, I'm not that far from there. I'm also close to agriculture, both sides. So we can ask him a little bit about the agriculture, but the main focus is the laws related to the startups. What are the requirements? What are the legal tax structures? What are the funding requirements? What do the VCs think? What is Silicon Valley mindset is? That is what I'm going to do. I'm going to, without a further ado, I'm going to bring Roger Royce to the main stage. Welcome, Roger.
Thank you. Good to be here.
So tell us a little bit about, I explained to you, you're a lawyer, very, very well-known lawyer in Silicon Valley. I met you a long time. You're a friend of mine. And, I don't have too many lawyer friends. You're one of the very few. But tell me that you have a lot of good positions in California Bar Association. You did. So what else? I forget anything that you want to add something to the qualifications?
Well, I don't blame you for not having many lawyer friends. It's the most exciting people in the world. You ever been out to dinner with a lawyer? Boy, it could be pretty long dinner. By the way, that is quite an opening you have. I don't think I've ever been on a webinar, and I've done a lot of these. I've done hundreds of these. I don't think I've ever been on a webinar with an opening quite that splashy. So congratulations on that. Certainly gets your attention, wakes you up here at 6 p.m. California time. But yeah, like you said, I do startups. I'm in Palo Alto, so by necessity, that's my audience. It's technically, we call it emerging growth and venture capital. So I work with all the new companies, and I've been a frequent attendee of your events, and I know you're very much health focused. And I totally get that. I like that. A lot of the companies I work with are biotech or health tech or precision medicine. And we're going to take a little bit of a turn tonight because we're going to talk about the legal aspects of startups and why startups, because I think that's where innovation really comes from in this country. I think that's the engine. Not only are startups and small businesses a big job engine, I think they're an innovation engine. Big, large public companies, they got public shareholders to report to. They're not as likely to swing for the fences like a startup is able to do, and make those really big advances. And we have been seeing huge advances in your area, in medicine, in health, and biotech. So we're going to take a step back here and talk about the legal side tonight.
Yeah, I wanted to ask you before we start the legal side of it, that Silicon Valley Bank is a big drawback in the Silicon Valley. Everybody is around the country and around the world are talking about. What is your take on that situation in the Silicon Valley Bank? Is the funding dried up, or what is the situation there? Before we can go proceed of that, that's a big topic around the world.
Yeah, it certainly caused a lot of people a lot of anxiety, and we were all busy for a little while, for about 5 minutes, I guess, until the FDIC stepped in last spring. But I don't think Silicon Valley Bank is more of a symptom than a cause of anything that's going on in our economy right now. And don't get me started about this comedy of errors that got us to where we are. But for where I am right now, from where I sit, yeah, there's not a lot of venture investment being made. But that doesn't mean deals aren't getting done. That doesn't mean companies aren't getting funded, because they are. They're just looking at other spaces. I'm seeing a lot more family offices who are a lot less, let's say they're more resistant to what's going on with interest rates, and way more private equity and corporate venture capital than before. And that is something that, in the old days, and by the old days, I mean like a year ago, or maybe a couple of years ago, people come to me and say, geez, should I go out for corporate venture capital? And I'd say, well, it wouldn't be my first choice. Corporate venture tends to have a reputation as being a little hard to deal with. They have changes of management, and one day you're the golden boy, and the next day you're out of favor, and you can't get anyone to come to your board meeting or sign your consents. But everything's changed now. Corporate venture is really a much bigger player these days. So private equity, corporate venture, family offices, and angels. Of course, the angel community, for sure.
Okay.
So,
Let us go with your startup. Can you? Okay, let me show you the startup. I'm going to start. Let me bring to the presentation to there, and both of us going to be in the side, or maybe I'll put in the bottom. Okay, can you see that? Yeah.
Yep, I can see it. I don't think I can move it though, but I can certainly see it.
You cannot move. You see if you can move your cursor on the top of the screen, it maybe you can see the moving, or on the left side. If you can't, I will move it for you.
Why don't we go to slide 1? Go to the next slide.
Slide 1. There's a Roger Royse. Startup law is going to talk about. He is a part of the Haynes Boone company, the law firm. Tell us a little bit of Haynes Boone. You want to say that a little bit more about that company, or you want to?
Yeah, so briefly, I've been with Haynes Boone about 3 years. Up till then, I had my own firm for the last 15 years. And Haynes Boone is an AmLaw 100 law firm. We have, meaning we're a large firm. We have offices all over the country. However, I am in Palo Alto, and I do emerging growth and venture capital. And almost all of my clients are tech companies in a variety of industries. But we've got enormous depth, so I can take them from start all the way to IPO, and I have done so even this year in this market. Okay, I'm just going to go through a handful of issues over the next hour that I think you all ought to watch out for. And this is just geared to the startup founder or the investor. And these are kind of the major legal issues that come up in your company, because these days it is just so easy to do everything yourself. You can go online and you can form your own company. You can download your own documents. You can get in all sorts of trouble. So let me just kind of give you the top things to watch out for. So number one, when people come into my office, it's not very often there's a sole founder sometimes, but usually there are co-founders. And they sit down in my office and they have an idea, or they have something that they want to put in, they want to wrap inside a corporate vehicle and then go out and get financing, and, and then we all get rich. But the very first question I'm going to ask people is, are you sure that you own this idea and you own this intellectual property that you're about to monetize? Because almost always they have a day job and they develop this on nights and weekends. And that's fine. That's okay. However, what we want to avoid is them commercializing a product or an idea that belongs to their current or past employer. And here in California, we've got a really good rule for this. In fact, it's statutory. You can't even contract out of it, like a lot of things in California. And that is our Section 2870 of the Labor Code. And it's pretty simple, right? The idea for it to belong to you and for that IP to belong to you has to be developed on the employee's time, not the employer's time. The employee cannot have used the employer facilities, so you weren't doing it at work, typing on their computer, using their lab equipment, etc. Thirdly, not related to the employer's business. And then fourthly, it doesn't result from work performed for the employer, right? So if you were hired to build a widget and you came up with a gadget, the gadget belongs to your employer. Now, it's that third prong that usually gives us the most trouble, because the other three are pretty easy to know. Those are bright line tests. But this not related to employer's business, well, that's the kind of law, that's the kind of rule that keeps lawyers busy because we have to interpret that. And there's plenty of law on that out there, and you can go read the case law to get an idea what that means. But this is the area where you don't really want to be on that line. You don't want to be close to that line. You want to be bright line, one side or the other. So just be really careful about that, because this is a practical matter. It doesn't take a whole lot for an employer to claim that what you're doing is so closely related to what they hired you to do that it belongs to them. Now, there are some best practices in this area. And, the best practice, of course, is not to take any of your employer's IP, right? You don't take their computer, you don't take their data, you don't work on their machines, you don't do it during work hours, etc. You just have very good log records and very clear proof of what you did on your own time and not on your own machines. Now, what happens though if you're the founder, that you didn't have a prior employer and you're a little worried about your co-founder who did? Or maybe you're bringing on a third person. Maybe you're bringing on a CTO after you formed the company. Well, you want to make sure that you're not going to get one of those nasty letters from the employer that says, hey, we want to remind you that guy you just hired used to work for us, and we've got a real strong confidentiality agreement and invention assignment, and we're going to enforce it. So if you're taking anything that we think is ours, you can expect to hear from us. So you don't want to have that problem. So you'll get representations, very specific, direct representations from your people that says that where they say, look, I'm not taking anything from my prior employer. I own everything I'm bringing. Nobody has any claim to this stuff. So dot your I's, cross your T's, be very explicit, and be honest, and you'll be fine. If, however, you do happen to be close to that line, all I want to say is avoid social media. Social media, it's kind of funny. This week I've been watching this. I don't want to say binge watching because I don't do that, but there's a program on television called Web of Lies. It's about people, getting in trouble online and crime being committed online, and it's interesting just how often the police track down the bad guys through social media, because people just can't help bragging about whatever it is they've done, good or bad. So just be warned that whatever you're doing on social media, people are watching. So you wouldn't want to post about your great new startup company while you're employed by some other company. That looks really bad. It's technically possible, but you're just asking for inquiries. So claims by prior employers, let's avoid them. That's kind of like number one. It's the very first thing. Okay, moving along. This one, next slide, importance of documentation is the next slide. And, I can't stress how important paper is in this case. Even if it's electronic paper, you got to have something You got to have agreements. You got to have something in writing. You need to have evidence. And it's almost every other day that I see people that just wait too long. In fact, just today I talked to somebody who has been operating informally for more than a year with his or her co-founders. And I'm telling you, you were just asking for problems. You were just asking for trouble, because people's memories are going to change. Their recollection of events is going to change. When it comes time to do that financing, they're going to remember that they were promised a different amount of ownership than you remember them having, if you ever even had that agreement. So don't just rely on emails. That's really bad. It's easy to say that's not an agreement. Get your documents in place. The sooner the better. The sooner you can sleep at night. It's just a tragedy when I see this, and I do often. You get a company like that salmon swimming upstream. They've managed to make it. They've got product market fit, right? They're in the right place at the right time. They got the right team put together. And they got an investor that really wants to invest in them. But they messed up because they didn't get anything in writing. And now nobody knows who has what. You are dead on arrival, my friend, dead on arrival. That company is done. Now, theoretically, you can go back and get everybody to agree later, which is what we all think is going to happen. I will tell you, out here in the real world, it's not how it always works out. All right, so equity ownership, that's the big one. Of course, that's the one everyone thinks about. Right, so you're going to write on a napkin, I own 5%, I own 50%, whatever it is. And I've seen a lot of napkins like that. These days it's emails, but in the old days it was bar napkins. And I'm not kidding. I've seen so many people come into my office holding a napkin. So that's the easy part, equity ownership. But there's a lot of other things. Vesting. Are you going to put a vesting schedule in an email? Not bloody likely. I think you're going to want to have an agreement. Investing is super important, because what if somebody leaves before you start, before you get going, before you get traction? You need those shares back, those unvested shares. You know what vesting is? That's the idea that you earn into your shares through continued service to the company, right? Now, that is super important, because the founders have a pool of stock, and the optionees have a pool of stock, and the investors have a pool of stock. That's kind of how I think about it. Well, your option pool is going to be X. We all know that. We're not going to change that. The investors are going to take what they want. So the founders is going to be a mathematical function. It's going to be what's left over. And if you've already promised an unvested chunk of that to somebody who's not contributing, that's that much less that's left over for the founders. And you might say, well, okay, my bad, I guess I'll just live with that. But it's not that simple. The investor may say, and I have seen this happen many times, look, I don't believe that you remaining founders are going to stay with this company with how little a stake you have left. You gave too much away, right? You should have had vesting, so the person who's not contributing is forced to give stock back to the company when they leave before you get to traction. Third place, this comes up. This is more subtle. This is one you probably wouldn't think of unless you've been through it, several times. Eventually, people are going to be making contributions in a typical startup scenario. They're going to be putting in cash, services, intellectual property, facilities. You get to use my garage, whatever it is, time. So you might all have different expectations as what they're getting for that. In fact, I can almost guarantee that you do if you have more than two founders. So let's use the easy one, cash. So suppose that you have, your service partners putting in their time, you got your cash partners putting in some money to keep the thing moving along until you can get funded. Well, what are they expecting for that? Because in their mind, they might think it's a loan. They might think it's just their share, their contribution. You're working, I'm putting in cash. Or they might think it's something that's going to turn into stock, preferred stock, when you finally do a financing. You better get that in writing, because I can guarantee you are setting yourself up for a dispute when that issue comes up. So let's just clarify. And I can also pretty much guarantee you that people are going to take of those three alternatives, they're going to take whatever position puts them in the best, in the best position. Just a couple other points to make about this. I say get documentation, and almost anything is better than nothing. You need to be surprised how little it takes to satisfy the law. Unfortunately, the dark side of that is that anybody can go online and download anything and sign their own agreements. I could go on and on with horror stories about people messing that up, because you don't know what you don't know. There are unknown unknowns. For example, you might download that Y Combinator safe and not really understand what it says and just how investor friendly it is. And that might not be what you intended. If it is, that's great, but it might not be. So just be super careful about do-it-yourself solutions. Or you might download all those corporate documents and form your own company, not really understanding what that means for your contribution and what assets you've assigned to the company, what you've held back or what you haven't, or what you should have, etc. So there really is a lot of judgment in this. And yeah, artificial intelligence is great. It has not replaced judgment, not just yet. Okay, I guess we're moving along. Tax planning. It's actually really good, Ramona, that you're flipping aside, because you can keep me going, because sometimes I get on one of these points and I just talk and all my time. Because I've seen, I've been doing this for 40 years. I could tell you story after story on each one of these. I'm not going to do that. I'm going to keep moving really quickly. And if people have questions and want to make this interactive, I'll let you, tell Ramona. Tax planning. Nobody does any tax planning in a startup world. Why should you? You're going to be a Delaware C corporation. What's all this other stuff? Why is it important? Well, a couple things about that. So number one, choice of entity. Every lawyer has struggled with this, except in startup land where I am, where everything seems to always be a Delaware C corp. But up until, I guess, until 2018 anyway, we all struggle a lot more with this issue. What kind of company should you be? And we all have rules of thumb, but there was surprisingly very little thought is often put into this decision. And you can put too little thought in, and you can put too much thought in, and you can come up with no solution, just a lot of alternatives with pros and cons. And that's not very helpful to you as an entrepreneur either. And I've written, articles and blog posts, and you can go online and you can find just tons and tons of commentary on all of these really interesting legal issues. But I don't think that's what you want, is a lot of legal theory. You want a solution. So I'm going to give you a really easy rule of thumb. This just kind of came to me one day, probably in the shower or something. It was just an epiphany that here's my rule of thumb. If you are a go big or go home company, then you should be a Delaware C corp. What do I mean by that? I mean my typical Silicon Valley startup. We're going to form a company. We're not going to make any money for a long time, because we're going to get funding and we're going to use that to build our user base. And then we're going to sell the thing and hopefully never have any taxable income between now and sale. And we all have a big capital gain at the end that we may or may not get taxed on. If we don't get that funding, we're not going to have a company. We're going to have a big smoking crater in the ground. All right. So go big or go home. We're either going to, it's either going to be the next big thing, it's going to be a huge success, or it's going to be nothing. There's no in between. That's a Delaware C corp. If you need venture capital to get you where you need to be, and the payoff is potentially humongous, that's a Delaware C corp. Let's just start with one. That's easy. That's most of my clients. On the other hand, if you're a lifestyle business, right? If you operate a yogurt shop down on the corner and you're going to make money from day one, and you're going to provide a pretty good living for yourself, and you're going to run it for 20 years and then pass it along on to your kids, well, that's not a C corp. That would not be tax efficient. That's some other kind of entity. That's a pass-through, an S corp or an LLC. And I won't get into the intricacies of the tax. All I'm saying is that this takes a little thought. You got to figure out which category you're in. And a lot of my clients, they come to me and they say, you know what? I could be both. I could be profitable right away. because we have a big service element. On the other hand, I could get funding. In fact, I want to try both. I want to go down both paths. I don't know how this is going to go. That's when I use a limited liability company, because it's super easy to incorporate that later. Now, I say super easy, but just keep in mind there are some traps when you do that. There are some tax traps. So, we just have to be careful about that. And it's really not an option if you've got foreign founders or foreign stakeholders. There's tax reasons it's possible, but not optimal. Let me put it that way. So, but otherwise, if not for those things, I'll do an LLC and we'll convert it later. And when do we convert it? We convert it when we do a financing, or we convert it when we get too many safes and you start to look too much like a corporation. Then we get really careful on the conversion that we don't trip up any tax rules, because it's possible to do that. So it is complicated. Got to warn you, flexibility is complicated. Just keep that in mind. That's a maximum mind. The more complexity you can live with, the more options you have, the more flexibility you have. This is example. Now, the final thing I'll say about tax planning, since we're already talking a lot on this slide, is the four greatest letters that ever entered the Silicon Valley, QSBS, qualified small business stock. It is the biggest giveaway I've ever seen. And it is really such a huge benefit to investors. I think that is part of what's fueling a lot of the angel fueled startup growth, which is a very good thing for this country, no doubt about it. But part of what's fueling it is the qualified small business stocks exemption. What is that? If you, as a founder even, or an investor, or anybody who buys stock in a company or gets stock for services, property, or cash, if that stock is QSBS and you hold it 5 years and then you sell it, you don't pay any federal tax on the gain up to the greater of $10 million or 10 times your basis. Okay, think about that for a minute. You can have a tax-free exit. If you're unlucky enough to be in California, you're going to pay state tax, of course. But as a federal matter, no federal tax. That's a huge gimme. And investors know that. And investors love it. And investors want you to make sure that they're going to get that. So just be careful about that, because it's very cookbook. And you have to jump through a bunch of hoops to get there. And I give those opinions regularly. And then there's a bunch of things you can't do that are very counterintuitive to maintain that status. So I just want to point it out. All right, let's move on to the next slide. So see there, tax planning is something that, we shouldn't just take a pass on. We have to put a little thought into it. Employment laws. We need to be careful, especially in startup land, because startup companies don't have a lot of cash. They don't really want to pay workers' compensation premiums. They don't want to pay payroll taxes. They don't want to pay their payroll service provider, to set up, accounts, etc. So they just misclassify everybody and treat everybody as independent contractors. That's another dead on arrival issue. That's an issue that could, kill the company. And the way I like to describe it, I don't know how many of you have ever listened to Reid Hoffman's podcast, Masters of Scale. He has one particular episode called Putting Out Fires that I reference a lot because it's such a good episode. And he talks about when they were building PayPal. And in any startup, you're going to have all these problems. Some of them deserve your attention and some technically do, but practically they don't. You got to let those fires burn because they're relatively small. Other fires are huge. They're the California forest fire. They're forest fires. You can't ignore those because they're going to take down your whole company. So when it comes to employment laws, I think of things like, I don't want to give you an example of a problem you should ignore because, otherwise someone's going to ignore it and then blame me. But I'll give you an example of a problem that is a forest fire, and that's misclassification. Because if you get that wrong, that can bring down your company. You could be sued under our class action lawsuit statutes. In other words, somebody can sue on behalf of themselves and all other similarly situated. And what are they going to get? They're going to get overtime. They're going to get waiting time. They're going to get vacation pay, or all that stuff that they were entitled to. Meal and lunch breaks, maybe not vacation if you didn't have an agreement on that, but meal and lunch breaks, all the stuff that's statutorily mandated. That can be huge. That can be really huge. Plus, you could have the taxing authorities after you because they're going to want back taxes that, of course, the putative employee did not pay. Now they're going to look into you, the employer, the startup company, to pay it. Workers' comp is going to be wanting their premiums. And by the way, workers' compensation is one of the few government agencies that will use the criminal statutes to enforce compliance with their obligations. And that's bad like you wouldn't believe. And then finally, California has a relatively recent wage theft law where they will go after the promoters of companies if your company doesn't pay its wages. So you got all sorts of problems if we get this wrong. So you can't get this wrong. And that's the big takeaway. And I'm talking mostly about California because this is a very tough state on misclassification, but it's state by state. And we now have the Department of Labor, Federal Department of Labor, kind of getting involved much more in labor law in this area than they used to be. And for example, they've been bringing enforcement actions related to to non-competes, which are illegal in California most of the time anyway, but maybe overly broad non-solicit agreements. I'll talk more about that later. Let's just say that there is a developing area of federal labor law, and the developing area of federal labor law really wants to, the Biden administration really wants to adopt the California rules nationally. And for those of you that are not in California, you are not going to believe it until you see it. I know that because I see lawyers come into this state from other states, and I explain to them what the rules are, and they never believe it. They just don't believe it. They say, nah, that just can't be. That just can't be. You can't get an employee to agree to that, right? Is it that hard to enforce an arbitration agreement? That just can't be. Well, I'm telling you it is. So, and just stay tuned because there is a movement that is gaining it's gaining momentum to make the California rule the federal rule. Okay, next slide.
Okay. IP protection.
IP protection. This is a big one for my clients because they're all tech companies, right? So, where to begin? So let's begin with, there's a lot to talk about here for sure. So we all know about patents. So number one, I'm a big believer. I'm not a patent lawyer. Okay. I know when to call patent lawyers, but I'm not a patent lawyer. Nevertheless, I want my clients to be valuable. And I want them to get funding. I want them to get a good valuation. And I want them to not be taken out of the game when a competitor's patent pops up. So I'm a big believer in patents. All right. Patents give you a lot of protection. The problem with patent, of course, is that the protection is limited to a certain number of years. You will eventually, when the patent issue go public, what you've done, so everyone can see it. That means your big, humongous, large company competitor is going to know exactly how you did it. And maybe they'll infringe, and maybe you got the money to sue them or not. So there are some issues, with patents. What's the alternative? The alternative is trade secret. What is a trade secret? Trade secret is for most of my clients, it is their most valuable asset. Okay, a trade secret, it's proprietary information. So number one, it's information, and it's valuable information. Number two, it's secret. The world doesn't know about it. It's probably what gives it its value. And thirdly, and this is the tough one, you have taken some steps to preserve the confidentiality of that trade secret. Now, the first two prongs are pretty easy. It's confidential, it's information, it's secret, it's valuable. That's pretty easy to prove. Third one is where companies mess this up, right? The third one, have you done enough to keep it secret? So do you have NDAs in place? Do you have NDAs, confidential information agreements, with all your employees and contractors, and NDAs with everybody you show this to? Do you have a good trade secret policy so that not everybody in your company can easily access your trade secret information? Do you have a good cybersecurity system? So you're not making it super duper easy for it to get hacked. You have to take reasonable steps to protect it. And you might be surprised how little it takes to lose trade secret protection. For example, there was a case during the COVID lockdowns about a company that a tech company that didn't know how to use Zoom. Imagine that. And they opened up their Zoom call to the public, and on that call they disclosed trade secrets. Well, guess what? It's no longer a trade secret. It's out there. So that's a super careful one. So I know what you're thinking out there. You're saying, okay, well, I got this valuable, that sounded a lot like a patent, which you just described. It sounded like an invention. So I got patent protection, I got trade secret protection. So I think what she said is if I file a patent, everyone's going to know about it. But then I got patent protection. If I don't file for a utility patent, no one will know publicly what I'm doing. But I don't get this federal protection, and I could easily lose it. So what do I do here, right? So that's kind of the trade-off. And here's, again, rules of thumb are risky, but I'm going to give you one anyway. And keep in mind, you need a lawyer. I'm not your lawyer. Talk to a lawyer when you do this, because it's all fact-based analysis. And that goes for every single slide, by the way. But here's a good rule of thumb. If what you have is easily reverse engineered, oh boy, you better have a patent, right? Because that's the only way you're going to protect it, right? Because if your trade secret gets reverse engineered, it's no longer a trade secret, right? On the other hand, if what you have just cannot be reverse engineered, I might keep that as trade secret. And most companies I work with, they have patents and they have related trade secrets that are going to constantly be changing, like their software code, which is usually trade secret, and then patents, some other aspect of their invention. That's kind of step one of patent strategy. And in my book that I'll talk about a little bit, I've got several chapters on patent strategy that are more business related that we can go into, but that's the legal aspect of patent strategy. All righty, why don't we move on to the next slide? How are we doing on time here? Boy, we are like right exactly on. Good job, Romana, with those slides. Trademarks. I know I just told you that my client's most valuable asset is trade secret. Their other most valuable asset is trademark. Kind of depends on the company. And let me tell you why. So think about what a trademark is, right? It is your right to protect, to keep people from using your name, your logo, your fanciful design, something like that. It is really inexplicably tied up with your brand for a lot of companies. I mean, just imagine, would there be a Snapchat without the Snapchat trademark? You can think about that for a lot. Would there be a Twitter without the Twitter trademark? Well, I guess there would be. I guess now it's X. But unless you got Elon Musk promoting your company, you probably want to be really careful that you own your trademark and you're protecting it, right? So the first thing you should do, because you want to avoid the scenario where you put a ton of money into building a lot of goodwill, meaning customer market recognition and acceptance of your mark and the identification of your mark with your business, your product, your service, before you put a lot of time and money into that, you want to make sure somebody isn't going to come along down the road and say, cease and desist, you're using my trademark. That's infringement. So stop, please stop. How do we do that? Number one's really easy. Do a Google search, right? Or a Chat GPT search these days, I guess, or a Bing chat search or something. Do a search. Do the easy, cheap, free one now. Find out if anybody is out there using that mark. Number two, go in the Patent and Trademark Office and do what we call a knockout search. Make sure nobody has registered that trademark. And then number three, we will file a registration. And I'm not going to go into all the reasons why you want to do that. I'm just telling you, you want to do everything you can to protect that mark, because you might be in the kind of business that your brand is going to be so tied up with the mark that if you happen to lose it, you lose a lot of your value. And I have worked with companies that have come out to the edge of that, and had to negotiate big settlements because, look, if my name isn't, XYZ anymore, people are not going to know who we are, what we do. They're not going to come back. So just be super careful about trademark. And we could talk a lot about trademark. What's a strong brand? What kind of brand to use? And you want your trademark, not to be subject to challenge if possible. By the way, think of the most powerful brand, the powerful trademarks that you know of, right? Think of, what do they all have in common? Well, when they first became trademarks, they were not descriptive. Now, some of them eventually became descriptive and they lost their protection, right? By descriptive, they don't just describe what you're doing, right? So I couldn't trademark lawyer, even though I'm a lawyer, I can trademark that. That's merely descriptive. So, and they're not words, commonly, used words. They're not even foreign words that have that same meaning. Sometimes they are, but that's not a great mark. That may be subject to challenge. What they are is made up words, right? Google, Exxon, Xerox, Twitter, those are the best brands, because people aren't going to say, oh, well, that's just descriptive. You can't trademark that. Okay, we're on to another tax related issue. And I have to spend some time on this because this is a sleeper issue. It's just so hard to miss. And I don't want you to miss it. And this is another one that you might not believe it if I don't tell you about it. And it's not just taxes, it's employment related taxes. And these issues loom large in the startup world because everything you're creating is based on sweat equity, right? You're building it through your services. Well, that's a bad answer in tax oftentimes, because we've got a couple of rules that, let's think of it this way. The tax law disfavors compensation. It disfavors income from services, and it favors income from capital. In fact, if any of you have about a year of your life to devote to it, you might read, there's a famous economist just wrote a book on wealth taxes and how capital is increasing throughout the world at a higher rate than service wealth is. And this is one of the reasons why capital gets taxed at a lower rate than services. And I'm not going to get political. I'm just telling you that the tax law disfavors services income. So we want to avoid that if we can. And a lot of times we can't. We can plan into it. There's a big difference between selling the product of your services, which is an asset that you've created. Big difference between that and being paid service income to develop that asset. And sometimes a lot of our planning is around that on the tax side. But I'm not talking about anything even that esoteric. I'm going to go to the biggest issues in startup that are going to hit you. Number one is our Internal Revenue Code, Section 83. And that's the code section that taxes people on the receipt of property for services. Well, think of a good example of the receipt of property for services. Can you think of one? I can think of one. Stock. People get stock all the time for services. That's the wrong answer. We want to avoid that result as much as we can. And there are plenty of ways to plan around that, right? We can get our stock for compensation and tie it to a vesting restriction. So it's, and there's case law that says that's just fine. We got great case law on that. There are ways we can plan into this to avoid tax, but you can't ignore that issue. And where we can't plan around it, or at least not very easily, is if you got a company that's got some traction behind it, it's issued its stock, it's got a little bit of runway, and then we bring in a new person and we give them stock and they don't pay for it like they should. And they end up getting taxed on the value of the stock. Now, I know that there is that's Hollywood attitude in Silicon Valley, that startup companies are worth nothing, almost ever, until you sell them or until you finance them. And you heard it here first, folks. That is some Silicon Valley lore that I think is going to get exploded. under what's going on with the IRS, which has just gotten a whole bunch of funding to go out and do audits. And, eventually they're going to pick up on this issue. And you're going to see that valuation assumption challenged. And I'm always nervous about it. I tell people it's an issue. I say, let's kind of dot the I's and cross the T's and be super careful, because eventually, it's just going to take one humongously successful case or audit, and then the floodgates will open. So how do we get around it? Well, we don't have stock for services. We have stock for cash. We have stock for property. Before we leave the employment-related taxes, I'm going to tell you about the second humongous gotcha in this space, and that is IRC Section 409A. And that code section imposes an immediate tax and substantial penalties, both federal and state, for what they call non-qualified deferred compensation plans. And what that means is that if you do the work today, but you get, the reward for it more than a year from now, well, that is deferred compensation. You have to comply with 409A. There are exceptions that are huge, right? There are huge loopholes. Hate to say loophole, but there are huge ways to get out of the requirements of 409A, to not be subject to 409A. But you need to know about them, and we need to plan them. And then when we can't get out of 409A because the facts don't support it, then we need to comply. And for the most part, 409A is just paper. You just got to have the right paper in place. But you'd be surprised how many companies don't do this. And because the IRS is not audited startups, they get away with it, and they think that it's okay, and until that day of reckoning comes. All right, let's move right along. Securities laws.
Yeah, securities.
This is a big one. Again, it's so easy and today to just go online and download a safe, a convertible note. You can even download preferred stock documents. You can get so much trouble on your own without knowing it. It's the equivalent. We do a lot of medical, a lot of doctors here. It's the equivalent to do-it-yourself brain surgery. In my world, going online and downloading documents and selling securities. And if you don't believe me, I can introduce you to people sitting in jail right now for getting them. Right? It's serious stuff. Now, let me tell you why. You have both federal securities laws and state securities laws to comply with. And the federal side is, I feel like it's a little more cut and dried because we have one federal government in this country, but we've got 50 states, right? And most of them have some sort of what we call blue sky law. It's a state securities law that requires you to comply with their laws. And some states are a lot easier than others. The Western states tend to be a lot easier, but not always. Washington's got kind of a weird statute. The Northeastern states tend to be way harder. They want to make it hard for you to sell securities. So you really have to know where your investor is, and you have to make sure you're complying with the laws. And by the way, this is true even if you're crowdfunding. Even if you're on a crowdfunding platform, you still got to comply with the law. You still got federal and state compliance. And this is your obligation, right? This is the obligation, of the company. By the way, have you been following the cases recently, the cryptocurrency cases, right? We had
Sam Friedman.
not that one. I'm going to get to that, but why am I spacing it? I just wrote an article on this, a blog post, XRT. Anyway, there was a securities fraud case where the SEC, not securities fraud, sorry, securities compliance case, where the Securities and Exchange Commission brought an enforcement action against a company claiming that their token was a security. And it was sort of a mixed decision because the court ruled, it's a district court, they ruled that, well, it's not a security when it's traded on an exchange, but it is a security when it's just sold directly to institutional buyers. Okay, and just this week, last week, we got another court that went the other way on this issue that says, well, not so fast. We think it is a security in our court when it's traded on an exchange. This area is just so uncertain, the securities law around tokens. And it has been for a long time. And it's basically chased all of my crypto companies offshore. So I really don't do that work anymore because they're all, doing it in Singapore or Cayman or wherever they've gone. But nevertheless, we have US investors in crypto and in tokens, and we have issuers who are going to be real surprised to learn they're subject to US law. And we also have a Securities and Exchange Commission that, why bother with regulations when we can just go do enforcement actions? And that way we can really stick them, gotcha. We didn't tell you what the rules were, but hey, it turns out you're in violation of them. Well, I'm not going to talk about that. What I want to talk about is if you look closely at that case, they didn't go after only the company that was issuing the tokens. They didn't go after only the company that was actually using the tokens and giving them utility. They went after the founders of the company individually. Okay, so think about that. When you violate securities laws, it's not like any other creditor where you might be able to hide behind that corporation I set up for you or that you did online. Because when it comes to federal agencies like the SEC, you're not dealing with a creditor. You're dealing with an avenging angel, and they come after you personally. You know who else does that? I'm going to talk more about that in the next slides. So put a pin in that. Before we leave securities, I want to talk about two other things.
Oh, sorry.
Yeah, back to the securities laws.
Personal liability.
Let's talk. I want to finish on it. There's a couple things I want to say about securities laws.
Okay.
If you don't mind, because this is really important. The other thing we've been watching in the cases a lot are the fraud cases. FTX, Theranos, Nikola, et cetera, et cetera. And, a lot of us are sitting there watching what these founders did. And I'm not going to defend or either condemn anybody. I'm just going to tell you, watching what they did, a lot of us sit back and say, welcome to startup land. That's what founders do. They puff. They totally believe in their company so much that they will fudge a little bit. Well, here we got 3 of them criminally, that have criminal exposure for doing this. And it was a shock, when this, especially Theranos, because I know a lot of people, some famous people, some famous investors who got burned in that deal who said, look, they were just doing the kind of puffing that founders do. Well, what's the difference? Why did these folks get nailed and other people get away with it? And there's a difference between fraud and puffing. Puffing is, I got the greatest slide deck in the world, okay? Puffing is, just wait till you see my product. Every tech company in Valley is going to buy my product. They're all going to give us orders. That's puffing, right? I'm just telling you what I think might happen. Fraud is, every big tech company in the Valley has given us orders. Okay, that's a fact. If that's not true, that's fraud. All right, so there's a difference there, and sometimes founders step over that line. Don't do that. Don't do that. Okay. All right, let's move right along to personal. That brings me right into personal liability. So, I started this conversation, and I'm going to bring us right back to the very first comment I made. We want to form an entity. What kind of entity do we form? I didn't ask you the big question. Why do you need an entity at all? Why do we need a corporation? Why do we need an LLC? Well, the number one reason is because startup companies often fail. And when they do, I don't want you to fail with it. I want you to be able to walk away from that idea and go start the next company. And I have plenty of clients who didn't do well their first time out, but did well their second time out. And if you've heard me speak before, you've heard me talk about one of my clients who, I'm not making this up. He had almost 40 apps in the market before he found one that was successful. So he failed 39 times. The 40th one was one of the most downloaded apps in the App Store. Okay. If he had not, done a little bit of careful planning here, he never would have got to that 40th app. He'd be in the poorhouse. So I want you not to have personal liability. I want you to, put the risk where it belongs with the business. So I'm going to give you 6 things that you should think about. We already talked about one of them, security. Don't violate the securities laws. They'll come after you. And I'm going to put a / parenthetical. let's put the Small Business Administration in there with it, because there's that's not a security, but they're investing in their business. They're giving you money too. And the SBA has been out looking real hard at PPP loans, and the IRS has been looking at the employee retention tax credits, because people mess those up because those were really hastily put together, not really thought through statutes with regulations that are almost impossible to understand. And people understandably got it wrong, right? And you only had so much time to get your application in and get it. And now the SBA and the IRS is coming along asking for their money back. And they have ways of going after people personally for that. So that tax refund or that PPP loan that you thought was non-recourse to you, well, I hope you did it right, or you might be wrong. So anyway, securities, don't violate the laws. Number 2 big one, taxes. Pay your taxes. You don't want to be sideways of the taxing authorities. And the IRS can be bad. Here in California, the Franchise Tax Board can be worse. And the employment tax people can be the worst. And that's both IRS, and here in California, it's the EDD, Economic Development Department. So you don't want to be sideways of employment taxes. You don't want to not pay employment taxes, because you will be held personally liable for that. I can almost guarantee you that. And the IRS, they'll go after anybody who had anything to do with it. I'll show you cases of bookkeepers being held responsible for the taxes of the employees of the company, because they did the egregious act of keeping the books on this. Wages, there's this concept of wage theft here in California now, and you don't have to get the wage theft. It's just that promoters can be responsible personally for the wages of an employee. By the way, that has really always been the rule here in California under a little-known statute. It's just never been enforced until recently, because there's a more recent statute that has a lot more teeth in it. Fiduciary stuff. This is directors and officers. What I would say about this is you really ought to have D&O insurance. I know it's expensive, but if you've got stakeholders, meaning investors or lenders for that matter, really get insured. Get insured, because if things go bad, they might come after you personally under a theory that you were just grossly negligent with their money or whatever. You don't want that problem. Get insurance, because fiduciary is another way they get you. And then fraud we talked about, don't do it. I had a client ask me one time, says, how can I ensure that I'm not going to get sued for fraud, given all these terrible stories you told me? And I said, I got an idea. Don't commit fraud. Okay. You can insure. I can't even ensure you won't get sued, but that's a good strategy anyway. And then finally, contract. So in other words, if you sign a lease, your landlord's probably going to want you to guarantee it. Try not to, if you can, especially those big leases, because that's how they'll get you. They'll say, look, you agree, you contract it. So where are we on time? We are right at the top of the hour. So
at the top of the hour. Let me just Roger Royse. That is let me come together, and that's a Roger Royse. Is a law firm is a Roger Royse. What is the email address? Can you read that one more time, Roger?
Yeah, I'm not hiding. If you Google my name, Roger Royse, Royse with an S, Royse, you'll find me. But it's roger.royse@haynesboone.com.
Okay. Yeah, everybody can find you easily, much easier for you. So let me bring you I'm going to bring Harry Brook as a thank you for beautiful presentation. That is a very well informed presentation. Let me bring Harry Brook. Is a very Western name, but he's from Belgium. He's originally from Netherlands. He runs an accelerator in Belgium. And welcome, Harry. Tell us what do you think, and what do you want? What do you have any questions?
Thank you very much. It was very enlightening to hear and see. I did some work in Silicon Valley in 99 and 2000, but I have actually a question while listening, and that is the following: and that is globalization versus because I'm out in Belgium, and Netherlands, Belgium is for me the same country. I live in both. But I've done quite a lot of financing and fundraising for European companies. Actually, today there is a very big difference. And the minute you go into geopolitics and globalization as a startup, everything changes. And I would like, because the thing is, the laws in all the different countries, the protection in all different countries, the personal taxes in all different countries. It is, we say that we are globalized, but we are not. We are localized in everything what we're doing. And what struck me when I did quite a lot of work in the United States is the difference between states. And the cost you have to pay the minute you want to hire a lawyer and be protected in all American states. So if we talk about startups, then my question for you is geopolitics and all the aspects you if I look at it from a global point of view, being a startup, and I want to be present in all countries, it is almost impossible to do it. While I would say, because you're right, SMEs are the biggest job generators. 90% of all jobs come from SMEs in Europe. Now, what do you think, your opinion on what if I am a startup and I come to you and I'm an American based startup and I tell you, listen, I want to go international. I want to be in all the countries. What would be your advice?
Okay. So I should tell you, I can only take this one question. I'm late for my next call. But
Yeah.
I will tell you that Delaware is the king of corporations. It is internationally recognized. And I have companies that come to me from all over the world. And usually they'll develop their product in our market and they'll come into the US. We'll form a Delaware corporation. We do an inbound flip. We have a Delaware parent. We can raise money in the US and anywhere else in the world. So I hear what you're saying, and that's why Delaware is king, I think, in this space. So in my world, it's Delaware corporations, regardless of where you're doing business.
Let me introduce you, Brandon Kegel. He's a friend of mine. My son, actually, they grew up together. My son and Brandon. He went to Harvard. He went to Harvard Business School. From Brandon is from Dallas, Texas. Brandon, any questions? You're the true entrepreneur. You're a tech startup and all kind of things. So tell me something about you, Brandon, and ask question.
Hello, great to be on the call. Thanks, Ramana, for having me, and yeah, great to meet everyone here. Yeah, a couple things about myself. So I basically joined a blockchain startup very early on. We got acquired by Live Nation Ticketmaster, and after that, I'm building this nonprofit, and we got state funding in the 7 digits, and now I am starting a for-profit company with my brother as well as like a hedge fund type thing. But we're raising money from external investors on saves, and I'm wondering about unaccredited investors.
Yeah,
And
you
so
can't
like a couple of
don't do it. Don't take them. It's more trouble than it's worth. You'll be sorry if you do. Theoretically, you can
really
take them. There are exceptions, that you can, but it's just going to cause you problems down the road, and it's just not worth the trouble. So I wouldn't do that. I'm sorry, Amano. With that, I have to drop off. I'd be happy to
Okay, sir.
talk more with you about that offline, but I
Okay.
didn't
So
realize.
thank you so much. It's
thank you.
truly
Nice
an
to meet
honor.
you.
Thanks, everybody.
Roger, thank you. Just 1 second, Roger. Thank you so much. It's a truly an honor to talk with you. It's always privilege, it's an honor, truly an honor. Thank you so much.
All right. Bye.
Bye. Okay, guys, if you want to talk a little bit about our results, we can talk. Um, Roger is gone. So hey, Brandon, thank you for coming. Oh, just thank you all. I'm going to play. These are all guys. There's a little bit of a technology confusion there. So let me play some music because we went over the hour anyway. I'm going to play my son. He's also he's a music entrepreneur. is a neuroscientist and music entrepreneur. I'm going to play his music. Okay, so if you can be, so I'm going to. He likes. I'm going to play his music and say goodbye. Thank you for joining with all of us. Thank you so much.
Throw it all around the world, all around the world, all around the world. Throw it.
She a fly little diva that be going to my head, no Khalifa. We should travel to a land Wi-Fi couldn't reach us. Let's hit Rome or the home of the zebras. Either she just wanna take a little trip to Ibiza, hit a little window in Indonesia, kick it in Brazil like FIFA, and treat a passport like a visa. Model in France like damn Mona Lisa. Now she wanna dance on the pyramids of Giza and Chichen Itza, land in Geneva, then make it rain bands from the Tower of Pisa.
All around the world, all around the world, all around the world. Throw it all
Fly me out,
When you wanna jet,
fly me out,
when we coming back,
fly me out.
but you got it like that.
'Cause I'm burning.
Hype when I enter and hate when I'm gone. Nights out in Denver and days I'm alone. Flights out of Kenya straight to Iran, then back to the west, Sierra Leone. Trek to the east like Genghis Khan. She'll twerk in a burqa, it ain't haram. We can spend the winter seeing what the penguins on. To the earth while you play the song. Do it like left, right, up and down. Hit the North Pole and scrub the ground. This goes out to the wanderlust. If you come with us and just
Throw it all around the world, all